Hi guys, it's Kathy. I hope you're doing well. I don't know what we made it to. Wednesday. We have a stream tonight. Yes. Yes. Anyway, it's Wednesday. Um, we got the first one gets a little sad apart, but it's not for long. It's the judge we want to see. But I thought you should hear what happened. It's a juvie. The judge has to decide juvie or adult for this one. And we're going to hear a witness who was there and saw what happened. We're going to hear what happened. But then the judge comes on, and the judge is outstanding. Um, uh, Really, really good. And then we have two lighter clips after that that'll bring us right back to where we were. So let's get started.
See Gabe Ybarra?
Not until Ian and I had left the residence. We were on our way to go to his house.
Okay. Do you recall what time that was?
I would rough estimate. I would say roughly around 10, maybe 10:30.
And so, do you recall that evening? Was the weather clear?
Yeah, cold.
Okay. And I assume it was dark out at this
Yes,
point.
it was.
Okay. So when you're leaving this home, were you leaving with Mr. Foy?
Yes.
Okay. And as you were leaving the home, what did you first notice?
So we backed out of the driveway of the residence we were at, which is connected to Paige Dobson. That was their neighbor in that same duplex. Gabe had lived there as well prior to that. When we backed out, we started driving, I want to say west towards Meridian Casey's gas station area. They live, Ian and Foy and Shannon Barber, they live in a trailer park back there. And that's where we're heading to go get fireworks. And when we had passed the first, there's one street as you leave that residence we were at. And as we passed that, we had noticed, I want to say a black pickup truck had ripped in behind Paige Dobson's car. And that's when I had noticed Gabe was in her car, was getting stuff out of her car.
So I want to ask, as far as the people in your vehicle, was it just you and Mr. Foy?
Yes.
Okay. And you indicated you observed a black pickup pull in. Did you recognize that pickup at the time?
I had seen it prior. I want to say it was Gabe's pickup truck. I think at the time Paige drove a little car. So yeah, I believe it was Gabe's pickup. I'm not 100% on that, but I'd seen it before.
And the vehicle that you believed was Gabe's pickup, where did you see that vehicle initially go?
It just pulled behind Paige's vehicle on the side of the road where it was parked.
And you had seen Paige's vehicle before?
Yeah. Yes.
Did you see anyone get out of the black pickup truck at that time?
Gabe Ybarra.
And when he exited the black pickup truck, what did you observe next?
He just ran up to the car, opened the driver's side, and was sifting through the car. From where it looked as if he was getting property of some form out of the vehicle.
Okay.
I guess they were going through something. They're broke up or something. I'm not sure if they're fully broke up, but I know Paige just an hour prior to that was saying pretty much that.
I'm going to object to what Paige said. It's hearsay, unless he's present.
Well, Judge, I don't think anything that Paige would say at this point would go to the truth of the matter asserted for the hearing today.
I'm going to sustain the objection.
Good call.
Yes, Your Honor. So when you observed Mr. Ybarra enter this vehicle that you believe was Paige Dodson's, what did you do next?
I regretfully said to Ian, who was driving the vehicle, I was like, I'm pretty sure Gabe is in Paige's vehicle, which I believed at that time Paige would not have liked.
Okay. And Did you say anything to Mr. Ybarra at this point?
Not at that point, no.
Okay. After you informed Mr. Foy, what did you do next?
I can't remember 100% if it was before we hit the railroad tracks on First Street, or if it was right afterwards, but I know Ian right then flipped around and started heading back.
Okay. So at some point, did you observe Mr. Ybarra exit Paige Dotson's vehicle?
At that point, when we had made it back onto that location, he was already driving away. He was pulling out from behind her vehicle and he was driving, I want to say I'm not sure what the building is exactly, but he was taking a turn, or he was going around a block to get back onto First Street.
And up to this point, you hadn't had any conversation with Mr. Ybarra?
No.
Is that correct? So as you observe Mr. Ybarra's vehicle leave, what did you do next?
As he stopped his vehicle to get back, there was a stop sign as he went around that block, which Ian started following him. And when he got up to that stop sign on First Street, I don't know exact words, but Gabe was yelling something out of the driver's side window back at our vehicle.
And at this point, Mr. Ybarra's vehicle was still in front of yours, is that correct?
Yes.
As Ian was initially following Mr. Ybarra, was there anything about his driving, Ian's driving, that you noticed?
Mostly just trying to keep up with him.
Okay. You indicated at some point, Mr. Ybarra's vehicle stopped and was yelling back at your vehicle, is that correct?
So before we reached that moment, First Street hits 2 lanes to where you can turn to Athletic Park right there. And at that point, Gabe got into another lane and he had slowed down and we got ahead and then he was behind us. We reached First and Meridian at the stoplights there. And at that point, he had pulled up alongside the passenger side of our vehicle on my side.
Okay. I want to go back a little bit. When you pulled in front of Mr. Ybarra's vehicle, where was the direction you were heading at that point?
We were heading west towards Meridian Street.
Were you going towards a certain location?
At that point, I figured I wasn't 100% sure what was going to happen. I knew the original plan was to head that way, go past Meridian, and go to their house to get fireworks.
Okay. And then once Mr. Ybarra's vehicle got behind your vehicle, what did you next observe?
Well, at that point, it was just me and Ian in the vehicle, and it was just, I was just telling Ian to calm down and chill out pretty much. I was wanting to remind him of Gabe's age and that like best case scenario that night, if something stupid happened, like it's trouble for Ian.
Was Mr. Ybarra's vehicle following your vehicle once he was behind you?
Yes.
How did you make that determination?
He was behind us driving. I mean, really there wasn't very many other options he could have went to. Maybe that was already the direction he was going, but he was behind us.
You indicated before he started following you, he was in a lane next to your vehicle. Is that correct?
Yes.
Did you hear him make any statements at that point?
When we passed him, I didn't notice anything really being said or anything.
Okay. Now, as you're driving and Mr. Ybarra's vehicle is behind you, what happened next?
I had made the comment of what were you doing in Paige's vehicle? And he responded with something around the lines of, what the fuck does it, sorry about my language, Your Honor. But what the F is it to you? What business of it is it of yours?
Now, are you making these comments while you're driving?
No, we are stopped at a red light. I want to say it was flashing red at that time of night for just you to stop, make sure everything's okay.
Just want to make sure I understand the sequence of events. So you left and Mr. Ybarra's vehicle was following you after you had been in a lane next to him, correct?
Yes.
As you were driving, then you proceeded to stop again at another intersection, is that correct?
Yes.
Okay. Where was Mr. Ybarra's vehicle when you stopped at that
He
intersection?
pulled up next to us on the passenger side.
And that is when you asked him,
What he was doing in her vehicle.
and you gave us his response. After he made that response, what happened next?
There was just a lot of yelling. Ian and I accusing of, are you stealing from Paige? Are you taking something that she doesn't know of? Things of that. And him pretty much saying, mind your business, and getting very agitated.
I assume at some point you left that light you were stopped at, is that correct?
Well, it started to get to a point where Gabe and Ian were wanting to fight at that point.
How did you make that determination?
The words like, do you want your ass whooped? Get the F out of the vehicle. At one point, Gabe pulled right in front of us so we couldn't pull forward anymore right there in the intersection. And he hopped out of the truck. And at that point, Ian tried to jump out of the truck. I was still in the passenger seat. He had his door open and he was stepping out of the truck. And I grabbed Ian's hood from his hoodie and started yelling at him and yanked him back into the truck.
Once he was back in the truck, what'd you observe next?
Gabe stayed outside of the truck for a while. Ian ripped around him and started going forward. And then Gabe had gotten in his truck and continued across the street where we were. At that point, we turned, I do not know exactly the street name that Ian and Shannon live on that trailer park is on. But when we turned off to go to that trailer park, Gabe did continue straight. So I thought it was over. I thought that was the end of it.
Okay. And at this point, your vehicle is stopped, correct?
We were continuing down towards the trailer, and when he continued to go straight, Ian then backed up back to the stop sign to make sure he wasn't turning around or whatever it was. And at that point, we had seen Gabe's headlights coming back. He had turned around somewhere down First Street and was coming back. And that's when Ian took off.
When Ian took off, what direction was he heading?
Towards their trailers. I would say that heading south.
And at this point, was Mr. Ybarra's vehicle continuing to follow your vehicle?
Yes.
What happened next?
At that point, I looked in the rear view and I couldn't see any headlights or the truck. And that's when I looked over and his truck is on the driver's side of Ian's truck. And Ian ended up ripping up onto a curb into a field to the right of where we're going. I want to say back on the west side of that street.
Okay. And the vehicle was stopped at this point, is that correct?
Yes, we were stopped at that point in the field.
What did you observe Mr. Ybarra's vehicle do at this point?
He started doing donuts around our vehicle.
Now, if you could just be a bit more specific, what do you mean by doing donuts?
He just kept in his vehicle, just driving circles around our truck.
Okay. What did you do at this point?
I stayed in the truck and was telling Ian to back up and get the hell out of there.
And did Mr. Foy comply with that?
No, he did not.
What did you observe Mr. Foy do at that point?
At that point, Ian jumped out of the truck and said, either leave us alone or get out.
And did Mr. Ybarra have a statement in response to that?
He peeled off on the other side in the parking. I would say maybe 30, 40 feet away from us. He had parked his truck and hopped out.
And what did you observe Mr. Ybarra do at that point?
At that point, he was in a obvious stance to fight. He was ready to fight.
How'd you make that determination?
Just the way he was jumping back and forth, hands out. He was just jumping around right, pretty much as you would see a boxer or something, put his hands up and just pretty much squaring up.
And where was Mr. Foy at this point?
Mr. Floyd started to take off towards Gabe.
Was Mr. Foy running, walking? Do you recall?
He ran up.
Okay. Was the vehicle to Mr. Ybarra's, was the door to his vehicle open?
I want to say it was.
Now you're observing Mr. Foy approach Mr. Ybarra at this point. Is that correct?
That's right.
What did Mr. Ybarra do in response to that you observed?
He didn't back down. He just pretty much stayed where he was until Ian reached him. And then to me, at that point, like I hadn't even seen a weapon of any form. I tried to grab Ian and grab his hoodie again. I remember hearing his hoodie tear. He was not gonna let me intervene, trying to stop it at all. At that point, the decision had been made that they were going to get physical.
And when they reached each other, did you observe any physical altercation?
It was really weird. It looked like they were just slapping at each other. It looked like neither of them knew they couldn't hit nothing if they tried. It just looked like slaps that were missing all around.
Do you recall who struck first?
I don't recall who struck first.
As you're observing this, what did you see happen next?
What concerned me was when at some point I saw Ian grab his side and he said, wait. He yelled out, wait, wait. And Gabe was still looked like swinging open hands, just like slapping at Ian. And Ian went to turn to run away and he was holding his side, trying to run. He was slumped over, but he seemed to be running good to me. It didn't seem like anything was too bad.
What did you observe Mr. Ybarra do when Ian slumped over?
So Ian started to try to run, I want to say, to his driver's side of his truck. I think he was trying to leave. Gabe followed him. They ran around the truck, I want to say once or twice. And then at that point, I knew things weren't okay because it's not like Ian to be running away. And he was still slumped and he ran across the street on the east side of that street. And that's when he fell face first. And Gabe was, I want to say, had one foot in that street and I pretended to call the police. I didn't have a phone on me.
Did you yell out any statement about doing that?
Yeah, I pretended to be on phone with dispatch and I said, I think Gabe just hurt my friend. And at that point, Gabe took off running to his truck. And that was the very first time I saw the knife in his hand.
Which hand did you see the knife in?
I can't recall which hand exactly.
It was a knife in Gabe Ybarra's hand that you observed?
Yes, I saw a silver shine coming out from the bottom of his hand.
Okay. Do you recall how he was holding that knife?
As if it was in like a downward stab from what I remember. Because when he was running, his hands were coming out. And I saw the shine come from what looked like it was by his forearm or something when he was running.
You indicated Mr. Ybarra was heading back to his vehicle. Is that correct?
Yes.
Did you observe him leaving his vehicle?
Yes.
Was that the last time you saw Mr. Ybarra that night?
That's the last time I've seen Ybarra since today.
What did you do at this point?
I ran over to Ian and I remember yelling at him that Gabe was gone. Everything was okay. He could get up. We were going to go to the house and see what all was going on. And he wouldn't listen. So I rolled him over and his eyes were flipped. His eyes were open, but they were flipped back. And he was grunting and trying to speak to me. And I realized things weren't good. So I pulled his hoodie up and I saw 2 puncture wounds in his upper rib cage. and I grabbed his phone out of his back pocket to call 911, and then I put pressure on his wounds and tried to perform CPR on him.
You did get a hold of someone at 911 with his phone.
Yes, I did.
At some point, did law enforcement arrive at your location?
It took a lot longer than I would have liked. I saw when Gabe took off out of that parking lot, seemed like 2 seconds, and there was some police officer chasing right after him, which led me to believe I thought a police officer witnessed the entire thing because of how fast they got to him.
Brief moment, Your Honor. Mr. McKee, you indicated that you knew Gabe Ybarra from prior contacts. Is that correct?
That's correct.
So if you saw him again, you could identify him. Would that be correct?
Absolutely.
Do you see him in this courtroom today?
I do.
Could you point him out, describe what he's wearing?
Blue button-up shirt, dark pants.
Your Honor, I would ask the record to reflect that Mr. McKee has identified the respondent as the person he interacted with.
The record will still reflect.
Mr. McKee, are you familiar with the boundaries of Harvey County?
Not very well. Not too much other than the signs when you're leaving or entering.
As far as what you do know, this field where this altercation took place, was this within the boundaries of Harvey County?
I would say so, yes.
So I went back.
Okay. So defense came on, self-defense, he's just a kid, blah, blah, blah. Now the judge has to decide what to do. This isn't the trial. This is the judge deciding what she's going to do. And if you notice, the ladies are gone because the judge was gone for a while, watching videos, going through his school records. She dug into this deep. And now she gives us her decision on where she's going to put this case going forward.
Into my office and reviewed again the factors under KSA 38-2347 subsection D. I reviewed the autopsy report, the various complaints in Harvey County District Court in the juvenile system. I reviewed the school records quickly. I didn't look at attendance and those types of things. And again, read the letter from Jake Miller from Reno County Youth Services. So I'm going to go through the factors one by one. The first of those is the seriousness of the alleged offense and whether the protection of the community requires prosecution as an adult or as extended jurisdiction juvenile prosecution. It gets no more serious than taking someone's life. So this is a serious offense. But it doesn't stop there. It's the seriousness of the offense and whether the protection of the community requires prosecution as an adult. And so looking at the other evidence presented here today, in addition to this charge, Gabe Ybarra is charged with 6 additional person felonies that are pending. Not convictions yet, but they're pending. 6 pending in 3 different cases. There is 1 prior person felony for which Mr. Ybarra has been adjudicated. And in addition, there are 3 other pending cases, one of which includes battery, a misdemeanor, not a serious offense, but another person offense. I believe the community requires protection. The second factor is whether the alleged offense was committed in an aggressive, violent, premeditated, or willful manner. I understand from the questions here today, or I'm anticipating that there might be claims about the acts of the victim or witnesses, but it's clear that Mr. Ibarra had opportunities to leave the confrontation on more than one occasion and chose not to. At one point, he pulled in front of the alleged victim and the witness here today to prevent them, or at least attempt to prevent them from driving away. They did in fact drive away. He came back. He could have left when Mr. Foy jumped out of his truck, but chose not to do that. In addition, he then used a knife, and according to the autopsy, the stab wounds were to the chest. So they weren't wounds of, I'm just going to hurt you to try to get you to go away. Mr. Foy was stabbed twice in the chest. The third factor is whether the offense was against a person or against property. Greater weight shall be given to offenses against persons, especially if personal injury resulted. Again, someone died. Number 5, the previous history of the juvenile, including whether the juvenile had been adjudicated a juvenile offender under this code. That has happened. And if so, whether the offenses were against persons. That has happened. And any other previous history of antisocial behavior or patterns of physical violence. As I was going through the school records, counsel, I will tell you, I largely ignored everything from the 2017-2018 school year, because I'm aware that that is when roughly the time period before Mr. Ibarra was sent to the juvenile correctional facility. So I did look through those, but just looked very quickly because I was more interested to see what behavior was after that experience. And these are in no particular order. On March 4 of 2020, Mr. Ibarra was confronted by someone at school, an authority figure. He was instructed to go to the office. Food staff service complied and did not serve him as they were told not to. Mr. Ibarra then turned around and said to, I believe, Fred Becker, and I'm quoting, "Get the fuck away from me," and leaned toward me. He then repeated, "Get the fuck away from me," and leaned toward me again. He was close enough that saliva hit this reporter's eyeglasses. That was at the very least confrontational behavior with what I would consider to be threatening behavior. In December of 2019, Gabe Y was refusing to work on his project and insisted that he, quote, broke his Chromebook in half, end quote. Another student said he doubted that was the case. Gabe began calling him names. I won't repeat the names. The two got very close to getting into a fight, with Gabe taunting Aaron to, quote, "Hit me, come on, hit me, and I'll clock you." September of 2019, Gabe was bullying another student, and this student began cussing him out. Gabe has been causing conflict with this student regularly. He enjoys messing with him. He's done everything from moving his books and stealing a seat to throwing things, making fun of him. Last class with a sub, this student got so mad he punched a wall. I grew very concerned.
Oh, I feel so bad for this other kid.
We were worried a fight would break out. I tried to calm the situation and take both boys into the office to talk it out. However, Gabe went into the other direction and ignored my calls to him, and instead, I assume, left the building out the back way. I'm growing very concerned about having the two boys in class together, as there's an altercation almost every period that I have to calm down.
If I had a guess, I would think that might
In
be
August of
father, but I
2019.
don't know.
Gabe was asked to pull his pants up. Gabe ignored me and kept walking. Gabe was then asked to stop. He continued to ignore me. As was walking by me, still ignoring me, he was talking about his math teacher. Again, I'm quoting, "I hate my fucking math teacher. I'm about to slap that bitch." I would classify that as a threat. This is in the report. Regardless, the student was insubordinate. So there's a pattern on the part of Mr. Ibarra there's a pattern of physical violence with Mr. Ibarra. The next factor is the sophistication or maturity of the juvenile as determined by consideration of the juvenile's home, environment, emotional attitude, pattern of living, or desire to be treated as an adult. I personally don't find this factor as strong as the others, but as has been stated, I don't have to find equally on all the factors. I would say there is evidence that Mr. Ibarra wants to be treated as an adult because he certainly won't listen prior to Reno County Youth Services to any adult in authority over him. Number 7, whether there are facilities or programs available to the court which are likely to rehabilitate the juvenile prior to the expiration of the court's jurisdiction under this code. Our facilities or programs seem to have been exhausted. As has been mentioned, Gabe spent time at the juvenile correctional facility, and since discharge from that facility, we have many new cases that have been filed involving person felonies. We have ongoing disciplinary actions at school. I understand he's not in school anymore. But we've gone to the max in the one case and yet still have multiple cases yet to deal with. The last factor is in some ways the most troubling to me, not because of the lack of evidence, but it requires the court to basically make a choice. Because the last factor is whether the interests of the juvenile or of the community would be better served by criminal prosecution. I certainly cannot find that Gabe Ibarra's interests are better served by criminal prosecution, but I'm not required to make that finding because it's either or. And unfortunately, I do believe that for the sake of the community would be better served by criminal prosecution. And when I have to make that choice, particularly with the facts that have been presented here today, I have to choose for the protection and the best interests of the community. So I'm granting the state's motion to authorize prosecution as an adult.
None of them are here for him. They're all happy right now, even though they're crying. They're happy. Tears.
Counsel, I know we need to make further settings in this case. I don't know what the state's plan is with regard to the other pending juvenile cases.
Your plan for state now will file a complaint to go along with the motion being granted today. As to the juvenile cases, well, I'm going to ask the court to keep those in a status setting as we proceed through
Okay,
the adult prosecution on this one case. I believe we need to set a preliminary hearing date. We may need to set a defense motion if we want to claim defense.
Mr. Lane, how quickly would you anticipate the state being able to get that motion filed?
No, no
I'm
bond.
sorry, the amended complaint filed.
You know, I can have that by tomorrow. Say a day, but I was in my office for a few minutes. So
And it certainly doesn't, I'm not ordering that it be done tomorrow, but for purposes of scheduling, I want to make sure that I'm not scheduling too quickly.
yeah, sure.
So he's going to be tried as an adult. And also, tomorrow she's going to arraign him on the rest of his juvie. Not tomorrow, this was a while ago. Tomorrow in her world. On the rest of his juvie crimes. He has a bunch of cases pending. And they're all going to be packaged in a nice, neat little bow. And he's going to be tried as an adult for this. Which I'm just so glad to hear he's not in that school anymore. I would agree with the judge. Yes, he's a teen, not an adult. His brain isn't fully formed yet. No excuses. He's an adult. Okay, now we're going to change gears completely. We're going to go here.
Roby and Tim Davis
Okay.
on Corbett.
Okay.
This is a divorce.
All right. I see Mr. Flores already on the screen there, and Mr. Davis. All right, there they are, Mr. Roby Flores and Mr. Timothy Davis. And I believe we're here on F6902-18-4 in the matter of the marriage of Corbett and Corbett.
Yes, Your Honor. Roby Flores on behalf of Ms. Yada Corbett.
Tim Davis on behalf of Mark Corbett.
All right, gentlemen, what do we have here?
Judge, we're hearing a motion for entry of our decree. We had a Rule 11 agreement. Just by refreshing the court's recollection, we had a Rule 11 agreement that we filed with the court. It was e-filed back on 9/26. We then proved it up. And Mr. Corbett didn't appear at that hearing. We submitted the decree to Mr. Davis. He requested some changes in the name of the husband's company. We did that. And there was a couple of other things that we changed. However, my understanding, they want to change the times of the pickup and drop-offs that aren't reflected in the Rule 11 agreement and aren't reflected in the code as per the code that's reflected in the Rule 11 agreement. The decree that we have submitted to the court shows his pickup time pursuant to the Rule 11 agreement at 6 p.m. and he keeps them through Monday when school starts. On Thursdays at 6 p.m. pursuant to the Rule 11 agreement, and picks up Friday when school returns, Friday morning when school commences. And then obviously if it's his weekend, he picks up on Fridays at 6. The spring break is as per the code, and so are the holidays. And that's what our Rule 11 agreement said. Our Rule 11 agreement said, if you read on page 1, it talks about the first, third, and fifth commencing at 6, Thursdays commencing at 6, and holidays as per the code. The decree that we submitted has the holidays as per the code per section 153.314 and his spring break provision as pursuant to 153.312. They're wanting to change it to when school lets out. that wasn't our agreement. Well, believe me, my client wanted more child support, but that wasn't her agreement. She accepted less child support. So those are the objections as I understand them. And if the court will share a screen with me, I can show the court the statute and the Rule 11 agreement.
Okay, but there's no objection regarding the holidays or spring break, so. I'm not-
So what do you object to?
Well, whenever you're finished, I'll address my objection.
If the court can give me a screen, Judge, can I share a screen?
Okay.
It's ready.
I think it's ready.
Okay, in the Rule 11 agreement that was filed with the court, that was signed by Mr. Davis and I, we showed the pickup and drop off on the first and fifth Friday, commencing at 6 p.m.
Until Monday.
Monday morning.
Uh-huh.
And the same is true for Thursday, and that's what's reflected in the decree.
Mhm.
They're not objecting to the holidays or spring break, then I don't need to talk about that.
Mhm.
The summer possession, we made the correction. They had a complaint about the spring break. We corrected that spring break issue to comply with the code. And the holiday, the summer possession, they wanted a correction, and we corrected that so it reflects what the intent of the Rule 11 agreement was.
Mhm.
And other than that, that's my understanding of the objection. And I had brought this statute out because they had told me about the holidays, but if you will see, holidays is unaffected by distance, and it starts, if you can see the arrow, they begin at 6 p.m. And on the 28th, it ends at noon, and then ends on 6 p.m. on the back end. And the same is true with Thanksgiving. Thanksgiving began at 6 p.m. and end at 6 p.m. And that's what the decree reflects. Mother's Day and Father's Day, I don't think got all that corrected. So unless I have misunderstood their letter, they haven't filed any formal objection to our decree other than sending me a letter. So we're asking the court to sign the decree that was e-filed with the court today that reflects the Rule 11 agreement and that was rendered in the court.
Yes, Judge.
Yes, sir, Mr. Davis.
There's several issues with the proposed decree, and I've, since the middle of October, brought them to Mr. Flotta's attention. The first one is my client was awarded his company, and I've told Mr. Flotta's the name of his company is MDC Engineering, PLLC. That still hasn't been reflected in the decree. Under on page 22 of the submitted decree, under H7, Mr. Flotta's client is supposed to tender to my client $86,575.50. As per the mediated settlement agreement, it was within 120 days of the mediated settlement agreement. They keep putting it in the decree as 180 days. And I brought that up, but they haven't made the change, even though it's reflected right there in the Rule 11 agreement.
Hold on, so we take it one at a time. I agree that I see the Rule 11 says 120.
It's 120, okay?
I'm making that note on the decree so I can change that. On
Okay,
the NBC, I put NBC, but I think he's now wanting me to put LLC Engineering.
It definitely means
PLLC.
son of a bitch.
NBC.
Son of a bitch. Darn it.
LLC
Correct.
Engineering, or just PLLC?
No, it's MDC Engineering, PLLC.
I can't look it up right now. I have to censor a part coming up.
I'm making that handwritten note. I'll change it right now.
okay.
Also, I asked that the decree include a paragraph or point H9, which was where Mr. Corbett was pursuant to the mediated settlement agreement, was awarded all his clothing.
First of all, it's a Rule 11. First of all, it's a Rule 11, not a mediated settlement agreement.
I'm sorry, yeah.
But go ahead.
Rule 11, He was awarded, the agreement was he would get all his clothing, jewelry, and other personal effects located at the 1321 McKee Drive in Edinburgh. That hasn't been included in the decree. It was part of the parties' agreement.
Hold on, Judge. Let me just look here. It says any and all personal property in his possession.
Well,
And that's on page 2 of the Rule 11. Can you tell me? Where is it? You said it was in the Rule 11. I'm trying to see where it says that. I think I sent you a letter, though, if he had some personal items to identify it.
and I did, and we sent you a good list and we got no response. Okay, right here.
Right. So you're okay with the list they sent? I mean, it's been 5 years, Tim. I mean, whatever on that list, if she has it, she'll give it to him. We don't have a problem with that.
Well, he needs to be able to go pick it up. That's what we had asked as well. Because he also needs to get the vehicles. Now, Judge, with regard to the visitation, on page 1 of the Rule 11 agreement, it says Mark Corbett extended standard visitation. The parties live within 50 miles of each other, and it was always his intent that he would have extended standard visitation. Under 153, 31.7, and 31.7.1, that's where that's set out. So unless he makes an election, either in open court or in writing to the court, his visitations begin when school gets out on Thursday. And then in his off weeks, the weeks where he doesn't have the first, third, and fifth, he would have the kids from the time school's dismissed, and he would take them back to school Friday morning. This is during the school year.
Yeah, Judge, but that wasn't the agreement. If you look at the Rule
But the
11,
agreement, right, but the problem is,
the Rule 11 agreement specified the time that was signed off with his lawyer's authority that the commencement time would have been at 6 p.m. The negotiating was being done here. Trust me, Judge, that's like me saying, Miss Corbett is going to get X amount of dollars of child support, even though she was receiving $2,500 before, and she really wants the $2,500 because we believe that's really his statutory obligation, but she decided to take less. So never mind about this $12,50, Judge. Go ahead, bump it up to $2,500 because that was my intent. No, this was our agreement. My client conceded things, and his client conceded things, and what they conceded was the start time being at 6 p.m. on Fridays and on Thursdays, period. Not I'm going to get to elect later, not that I'm going to make some other decision. This was the agreement, and they want to go outside of this agreement now.
no, we want to go by the Texas Family Code.
Well, and we did too on child support, Judge, but we didn't.
So, but Judge, at the end of the day, here's the way it's set out on my client's first, third, and fifth weekends. He would have to pick the children up at 6 p.m. at his ex-wife's house, take them to school the next Friday morning. Then they would go home to mom's house, and he has to go back and pick them up on Friday at 6 and then have them until Monday morning, instead of just from Thursday through Monday morning.
But believe me, we understood that. And my client knew what she was negotiating. And she wanted to see her children after school on Fridays till 6 p.m. That's why she authorized me to enter this agreement. That's why Mr. Corbett entered this agreement. We don't get to cut and fish bait after the agreement has been approved and proved up, Judge. We proved it up on the record pursuant to this Rule 11 agreement. And he didn't make the election then either because he knew what he agreed to.
Because the election is for, the election he would make would be for what you want.
And
That's.
this, and this is where he signed off on it.
Okay. All right, what other objection?
That's all, Judge.
Okay, first of all, the name change, you got that, right, Mr. Flores?
Yes, I'm doing it in the decree as we speak, because I want to send this
The
over to the.
exact name of that company
Yes, sir.
with the PLLC, and then on the 180, that's gonna be changed to 120, right?
I got it. I'm doing that as we speak.
All right, and then what was the next thing? Oh, all the personal items. Oh, the list. You're gonna include the list also?
I
All
still
personal items?
float us a list.
What I'm going to put in the decree, I mean, and I want to word it right now, Judge, because I don't want to come back again. Let me get the decree up.
Okay,
Give me 1 second.
I
Alright.
just suggested it be H9 on page 22.
H9, page 22
Yes, sir. We
Okay.
need to add that.
of the decree.
Yes, sir.
Okay,
Hold
can
on,
you
Judge.
put that up, Mr. Rhodes?
I'm going to share the screen and put it up here,
All right,
and I'm going to go to,
page 22, H9.
So see
All
there,
right.
it ends with H8. So I was,
Right.
we need to
You want to add H9, and that'll be what's on the list, right?
all personal property that can be located by Miss Corbett.
No, that's not.
Well, the judge, well, Judge,
Can
here's
be
the
located.
well, here's the
That will be
problem, Judge.
located.
Well, look, Judge, here's the problem. It's been 5 years. If he says he's looking for a wrench,
Judge, my client's here, and he can speak to it. And then
Huh?
some of these things are family things, things from his father, tools, hunting equipment, fishing. I mean, this is not
No fishing gear on them.
there is no fishing gear on that list. Tim is speaking out of turn.
There's a lot of
And
fishing in this
on the
whole
list are tools.
court.
You know, I'm not going to pin down my client. Oh, she forgot to turn over a screwdriver that I know was there. Well, you
We're
know,
not in, Robbie, but we're not asking her to turn anything over. Just let him go over there for.
no, Judge. We're not going to let him come. We didn't go rummage through his house about things that he took that she may have wanted back. We have the list. She will produce all those items that she can find there at the residence. And if they're not there, I can't have her magically appear something that doesn't
To
exist,
what-
or he may.
To where will she produce them and by when?
He can come by to pick them up. That's all permanently located located at, what's the address?
13.
13 K Drive. Okay, Edinburgh.
Edinburgh.
Okay,
All personal property of you said personal nature, Tim?
I'd use the term clothing, jewelry, and other personal effects. And then I sent you the list. I think
All personal clothing,
clothing, jewelry, and other personal effects.
clothing, jewelry.
personal
other-
effects is too broad, Judge. That's my chair. This is my sofa.
No, it's not furniture or appliances. I mean, I've already made you the list. You can make a,
Personal jewelry,
And personal items.
jewelry and items on list that can be located shall be tendered to him at the residence. Pick a day.
Mark, are you there?
Yes, I'm here.
What's a good day that you can go pick everything up on your list?
Yeah. Friday, how about Monday the 5th?
Well, if she's gonna look for these things, hold on, let me just look at the calendar. Give me a second. How about December the 10th? That's on a Saturday. That way,
No, I can't do December 10th. But how about during the week sometime, not a Friday?
so I'm gonna pick a Saturday so it doesn't interfere with anybody's work or kid schedule.
Well, I mean, the kids are not involved in
But-
this.
but- Well, they're at the house.
They're,
you know,
they're,
they're at school.
they're at school, they're at school during this
Right,
time.
so what day?
Yeah, I had offered up the 5th, 6th, 7th.
She can't do the 5th. My client's here.
12th, 12th through
So give me a
15th,
date.
12th through 15th, any of those days, 5th through 8th, any of those days, 19th through 22nd. I mean,
December 5th?
and I do take exception with the can be located because we provided an exact list. And by the way, there is no jewelry. I don't have any jewelry over there. I
Well,
don't have any-
that's what I thought, but your lawyer said there was jewelry.
Well, but
That's
no,
exactly my point.
Roby, you've had the list since October, sir.
Judge, I'd rather address myself to the court and to Mr. Davis. What day? Give me a
Very
day.
Very well. I'll go on mute again.
Give me a date. How's December the 8th?
Yes, he had said any 5th or the 8th are good.
Yes,
December 8th, 2022 at 6 p.m. He's gonna be there anyway.
It'll be 6 p.m.
whoa, wait, not 6 p.m. because I pick up the children. How am I supposed to pick up the children and then haul a bunch of stuff back at the same time? Come on, let's be logical about this. Can we do it at noon? Can we do it at noon?
No, she works. How about at 5:30? That gives you 30 minutes to load whatever you're
But,
loading.
yeah, and then I'm supposed to return and get the kids at 6 o'clock by 5:30, which goes back to what we're talking about with it anyways.
No,
So I'm trying to offer up a solution.
I'm
So-
giving you one. Just,
How about-
I
how
asked you to-
How about not the time when I'm picking up the children and at least not 2 hours before? That way I have time to take the stuff.
How about December 7th, the day before?
Yes, absolutely.
How about December the 11th? That's a Sunday.
6 o'clock, December the 7th. I cannot do the weekend.
Why?
I cannot do that weekend.
It doesn't matter why.
She'll be happy to leave everything on the porch on December 11th, and that way when he finds time to go do it, he can go do it, Judge.
Really, come on, guys. I'm offering you 5th through 8th, 12th through 15th, 19th through 22nd, 26th through 29th, any of those days except the 2 hours before I pick up the kids, at least give me some time to unload. Come on. I mean, please be reasonable.
I'm thinking about it, Bren.
I'm trying to pick a day when he doesn't work, Judge, and my client doesn't work. I'm offering up December the 11th. It's a Sunday.
I'm willing to make time to get this done.
Right, December the 11th. Pick a time.
No, I told you it's not going to be on the weekend, Roby.
He won't be.
I'm telling you, I cannot commit to that weekend.
He's not in possession of the kids that weekend, Judge. I mean, it doesn't interfere with his
So?
possession.
What?
You know what?
He's offered you almost
commitment,
every
Roby.
week.
I told you that won't work. But I'm
Is that-
offering up
He
almost.
said the
half a
5th through
month.
the 8th, the 12th through the 6th, 15th.
How about the 18th? That's a Sunday. How
No,
about the 20th? December 20th? It's a
Yes,
Tuesday.
December 20th, great. Let's do that. Wait, what is December 20th? Do I have the children then?
that's a
It's
Tuesday.
That's fine, December 20th. Let's do that.
All right, December 20th.
At 6 p.m.?
Just work with me, guys.
6 p.m.?
6 p.m. or 5 p.m.
5 p.m. is fine.
What time?
5.
Let's do 5, so it's still light a little bit.
When there's a little light, at least.
Still daylight
gets
at
out of
5,
work at
right?
5. Let's compromise 5:30. Let's between 5 and
Yeah,
6.
at least there will be a little light left to work. Yeah.
A little bit of
All right.
light. So, okay, 5:30.
Okay, 5:30.
5:30?
Now let me go back over here, Judge. ELLC. And then
No,
That's
it's
MDC Engineering.
Engineering PLC,
MDC Engineering.
right.
This is a private site,
Sorry,
Josh.
engineer.
Is
Don't
that
read
correct
it.
now?
No, engineering is spelled with 2 E's and 1 R.
See how much you're learning today, guys? Uh-huh.
All right. Are we done?
But we're still objecting to the visitation schedule.
But the schedule, that's the one we know right now. That's the Rule 11?
Yes, sir.
Right, it's supposed to be the extended standard visitation.
Well, that's our Rule 11, Judge. It starts at 6 PM. That's what they agreed to. That's what my client agreed to.
Okay. When we had the hearing, that everybody showed up and we had the final hearing? What was said at the hearing?
It was following the Rule 11,
Okay.
and Mr. Corbett did not appear.
I was there.
Yes, but
Okay.
well, yes, and he was here when he signed the Rule 11. That's the
Yeah,
point.
okay.
He has the
Okay, it'll be
authority
the
to
Rule 11?
All right,
What else?
that's it, Judge. I'll e-file that with the court right now.
Would that be an amended one? Because he filed one already?
Yeah, there's a like.
It'll be amended. It'll be amended, Ruby, because you
Want me
already
to call it
submitted,
amended?
because you already submitted one, right?
Well, we submitted one, but it hasn't been signed. You can reject it.
No, because it's already there, then it's gonna be confusing.
All right, no problem.
It's gonna be amended.
put-
Yes.
I'll put amended.
It'll be amended. All right, anything else, gentlemen?
We
No,
want to
so
hear
that's
them
all.
fight
All right,
more.
thank you very much. Your excuse. Have a
We
great
want to
holiday.
hear them fight a little bit more. Okay, one more. Here we go. I don't know if this is a general demur or a special demur. I don't know.
All right, let's set the record up.
Thank you, Judge. We're before the court, state of Georgia, which was Joshua Ryan Poteet, case number 25
Joshua.
04638-10. Judge, before the court this morning, our defense motions. Mr. Booker filed a special demurrer to the indictment, one count of making a false statement, and he also filed a motion to disqualify District Attorney, Assistant District Attorney Lewis, motion to disqualify me, Judge, from prosecuting, continuing to be the assigned prosecutor on this case.
Joshua wants to disqualify the prosecutor. Disqualify the prosecutor. Sir, everybody wants to disqualify the prosecutor. You can't just do that. What's going on?
Defense motions, Judge, state's ready to proceed.
All right, do you happen to have an extra copy? You know, we're going paperless now, so I don't have copies. I can pull it up.
Right, and I have electronically, Judge.
Mine a whole bunch, but I can get them to, I don't need them. Got an extra one. If not, I'll just pull it up online.
No, I just have
One or the other. All right, you need them back?
I don't.
I can write on them. They're mine.
Different.
All right.
So I want to start, Judge, with. Did I get it right? I'm going to start with the mirror. It's pretty straightforward,
Well,
Judge.
that's good. If I read the other one, we're not doing it.
Okay, all right. Oh, so you want me to start with the motion to disqualify the mirror?
You could. No, I want you to start with mirror, just exactly what you said.
Okay, so the mirror is pretty straightforward and quick. So essentially, in this case, my client is charged with a July 10th unit. He was represented by an attorney, Charles Webb, at that time, and they set up a proffer meeting with an investigator for the Gwinnett DA's office, Investigator Thurman, and the DA on this particular case, Chris Lewis. And so in this case, the proffer involved a murder charge, that there were two other defendants that were charged. My client was out on bond at that time. And so they met with him in the DA's office, and he gave a recorded and by video and audio. And so based on his statements in that interview, the district attorney about a month later issued a warrant for my client for making a false statement under 16-10-20. Now, we never were able to do a preliminary hearing in this case because the officer missed each time that we were able to. And so ultimately they returned an indictment. And in the indictment, it's pretty straightforward, but they say that on July 10, 2025, that my client did knowingly and willfully conceal his involvement in the planning of the robbery of the victim of the murder, a material fact, by making false and misleading statements, denying knowledge of the plan to rob Abel Cassidy. So my motion is really straightforward. I'm gonna just get straight to the point so I can sit down. But in 16-10-20, the statutes can be proven in a couple different ways. And so essentially the best case I think that breaks it down was Dawkins v. State, but they can prove it by falsifying or concealing a material fact, by making a false statement or representation, or by knowingly making or using a false writing. So what you have to look at is the actual indictment versus what the 16-10-20 says. The state has elected to charge him under 16-10-20 that he did knowingly and willfully conceal. Looking at 16-10-20, falsifies, conceals, or cover up. They left out a very significant portion of the statute though. There's wording that comes after that that says falsifies, conceals, or covers up by any trick, scheme, or device of material fact. The indictment leaves out all of those wordings where there has to be a trick, scheme, or device of a material fact. And the reason that's important is by one of the more famous cases out of Atlanta is the Snyderman case, where there was a young lady who was having an affair with her boss. The boss manages to kill her husband. In that particular case,
Was this one in your motion?
I don't know but I have a copy of the judge if you need it.
Well, if I could circle it here, it's really easy.
I'll bring it to you in just a second. Let me just read off in the record my part of it. In that particular concept there, Judge, the Georgia Supreme Court of Appeals ruled that the concealment in 16-10-20 does not apply to passive non-disclosure. Rather, the statutory requirement that concealing a fact must be accomplished by a scheme, trick, or device requires an affirmative act on the part of a defendant.
So maintaining silence on an issue is not a false statement.
It's not a false statement.
That would kind of make sense.
And again, even
Of
if
course, it depends, I guess, what was purportedly said.
right, and
Remaining silent is one thing. Saying I was not involved, I don't know anything about it, it's something else.
right, and if the state is going to allege that latter part that you said that I don't know anything about it, that particular part, they're not able to say that because under their version of this case, under their allegation, that they didn't know about the very thing that they said that he failed to disclose about at that particular time. So they're not going to come forth, I'm sure, now and say, well, we knew about it and we asked him about it and he failed to disclose. They also would need to tell us if he made a false statement, what the actual false statement was, which they didn't. They're alleging that he concealed it. And so under this particular case, it says that a passive non-disclosure does not comport. This is the only copy I have of it. Do you want to review?
I'm very familiar with Snyderman. There's two cases that come up when you reference concealing.
Oh, is that
facts
the
in a
case out of DeKalb County?
It is.
It's not, Judge, it was the famous case where the lover showed up and killed the father in front of the daycare. There-
His name was.
Snyderman was
was the wife.
The wife and the husband that was here. Correct, yeah. So ultimately, Judge, under the way that the state has indicted under count one, there are pieces of the very 16-10-20 that they're trying to charge you under that they don't include in the indictment. So obviously, the indictment, if they're going to charge him under 16-10-20, the wording that is required in order for a jury to find him guilty if they're alleging that he concealed is that he must do so by any trick, scheme, or device of material fact. And that language under count one, which is the only count here, is not included in the indictment. So therefore, it would not be, I guess I could argue even that he could admit to doing that and not include that language in it and not violate the statute. The statute specifically says that those words must be communicated and a jury would have to consider that in order to. So I'm asking the court to grant the demurrer based on that language.
That's an interesting argument. All right, well, wait a second, I was trying, because this, I'm gonna give back.
Okay.
But I'm trying to make a copy. I thought I had it going. This guy didn't.
You have everything back there, copier, printer, and all that.
Oh, yeah, you gotta use it. There's all sorts of things going on.
Who charges by every
Particularly
6
with
minutes?
electronic evidence now.
That's crazy.
Part of the trial. All right.
For the love of God, if you ever attempt the world's oldest profession, do not charge by every 6 minutes. You'll get half pay.
I don't know. That case really, that whole scenario, so sad. Had a lot of contested issues here. All right, so his argument kind of makes sense that concealment wouldn't be making a false statement.
Well, I don't know if that's what his argument is, Judge. I think.
I thought it was, so you better tell me again, Mr. Booker.
The nature of his argument is that by the mere fact of him remaining silent, that he could not.
That would make sense.
Correct, Judge, but that's not what the state alleges in the indictment.
Okay.
In the language of the first, I think Mr. Booker has kind of blended a general demurrer and a special demurrer. He filed a special demurrer, but he's kind of arguing a general demurrer, Judge. So I'll kind of take those separately. The count in the indictment tracks the language of the statute, Judge. The state's position, just briefly, is that he cannot admit to the facts in the indictment and not be guilty of a crime. So I think it sufficiently tracks the language of the statute to survive in general. With that being said, Judge, I don't agree with Mr. Booker. The indictment charges the defendant with knowingly and willfully concealing his involvement in the planning of the robbery of Abel Castellanos material fact. I don't think there's any dispute to that. If that material fact is related, or the plan of that material.
Statements denying knowledge.
Correct, Judge. So he may
put him on notice.
Correct.
Under this statute.
Correct, Judge. So he didn't just remain silent. He made false and misleading statements denying knowledge of the plan to rob Abel Castellanos. Judge, there is a video of the recorded proffer interview. It's 53 minutes long. Judge, that is the only statement that the defendant ever made to the district attorney's office. So the question is not whether this indictment contains all of the or all of the facts and circumstances, but does it sufficiently apprise the defendant of what he must meet at trial? And obviously, Judge, the state's position is it does, that he made false and misleading statements, specifically denying the knowledge of the plan to rob the victim. Judge, that's sufficient, sufficiently specific to put him on notice of what he must meet at trial. So, Judge, we would ask the court to deny the special demurrer to the indictment.
Now, who do false statements have to be made?
Oh, well, I think, Judge, that's surplusage. Because
But it has to be made, somebody obviously it can't be made for stranger on the street.
that's correct, Judge, but it's alleged that they were made to employees of the district attorney's
And
office.
it's that, it's agency under this, I don't have the statute.
It's a agency of state government, Judge, is how it's alleged.
Okay.
Correct. So it has to be an agency of government, could be a city, county, state, but it has to be an agency of state, agency of government. Which my position is properly alleged in the indictment because district attorney's office is an agency of state government.
So I have two things in the indictment. I have willfully concealed, which ordinarily conceal, if you don't say anything about it, it's clearly not a false statement. But the state contends makes no difference because they clarify in the latter that he made false statements denying knowledge of the plan to rob. And interesting to see how that's proved, but.
And that's the manner in which he concealed his involvement.
Okay. Circle around you, Mr. Booker. Anything else on your motion? You get
Yeah, just
first and last.
Yes, sir. So the state says that it tracks the language of 161020, but what they still didn't tell the court how it does, because under 161020, if you read the very first sentence, falsifies, conceals, or covers up by any trick, scheme, or device of material fact. There is not the words trick, scheme, or device of material fact is nowhere in an indictment at all. So again, those.
It says they gotta put that in. I've seen these before. I can't remember trick, scheme. Or device.
Sure, it's part of the indictment, and I'm sorry, it's part of the statute, and under the Snyderman case, that was the point, but part of the point behind that, Judge, is that in that case, the Court of Appeals ruled that language, they actually have it in their ruling, that the concealment does not apply to passive non-disclosure. They go and they address
that, but the state's contending it's no longer passive disclosure when they cure it at the bottom.
Right, so
sentences or clauses of the indictment.
I agree. So what the state is saying that they're not alleging that he concealed, they're going to forward that he made a false statement is what they jump to at the end. So if they're alleging that he made a false statement, we would need to be on notice of what that false statement in fact is. We have a theory.
They kind of said that because denying knowledge of the plan and said false misleading statements, plural, were made to avoid.
Right. And so if there were false and misleading statements, we need to know what they were, because the 53-minute interview, they're claiming in a 53-minute interview where my client is communicating back and forth with the prosecutor that at some point he made a statement. That does not put us on notice of what that statement is. We can play jump all around the interview if we were to have a trial and say, well, in this statement he said it, or in that statement, we're not on notice to defend what in fact he said.
See, a lot of times crimes involve statements made by somebody else.
Mm-hmm.
Well, this is your own client.
It is.
It's not like he can say he was tricked or wasn't there.
No.
There's no knowledge.
That's correct, Judge. The state would need to be able to put in evidence, because what they want is both parts of the statute. They want the part that says knowingly and willfully falsifies or conceals. That's why they use conceal in that part. But then they skip forward to the second part, makes a false, fictitious, or fraudulent statement of representation. I don't know how they're able to do both of those. They're not, I'm not sure if you're talking about it, but I don't think that they do both. What they're trying to do is apply both parts of that to this particular statement that is made. We're not on notice of what that is. And I think the Snyderman case puts that right in the square for what we're arguing, Judge.
When do you have time to think of these things? You're in trial.
I don't know. But
you're still creative.
I try my best, Judge.
Under advised.
Thank you, Judge.
We'll go from there.
All right.
All right, let's go to what would be the basis to disqualify Mr. Lewis?
So that goes directly to this interview. So in the interview, it goes back again to the last
interview was with counsel, right?
Yeah, but it was with Mr. Luke. So let me stop.
Your client was there with an attorney.
He was. So, well, let me explain. 16-10-20, they're basing it based on a statement that was made to Mr. Lewis already. Mr. Lewis was there.
They said employee.
Well, the employees were Ryan Thurman and Chris Lewis. That was the two
I
things.
got that.
Okay,
That's why it's plural.
right. So it states, and this would be a comment that Mr. Lewis makes, not the investigator. The investigator is there, he never says anything. It's between this defendant and Mr. Lewis with his counsel there who says very little as well. Okay, Mr. Lewis says that 1 minute and 38 seconds into it to 1 minute and 59 seconds, he says, quote, anything you say here today, the district attorney's office is agreeing that it cannot be used against you, no matter what you say. Nothing you say can be used against you in your prosecution. Now, I would imagine that in a trial, that whether or not my client, quote, intended to mislead, and whether or not he was told what he was gonna say could or would be used against him, would be an issue that a jury would have to contend. And so Mr. Lewis was the person who found that.
That might even be a motion.
Right, exactly. So based on that, when he makes that proffer to my client within the very first portion of it, I don't know how we don't get a chance to cross-examine Mr. Lewis about what his intent was when he told him that. He, in fact, he can't deny that he told him. And so based on that,
You're right. Mr. Lewis can't be a witness in the process, although it would be pretty efficient. Save a lot of time coming in and out of
it would.
things like
So,
that. He can't do that, but I don't know that that's their call.
well, it's the defendant's call to be able to question anyone that was in the room. We can't question Mr. Thurman because Mr. Thurman, he didn't ask my client any questions. We don't have anyone else to question other than Mr. Lewis because Mr. Lewis was the one who conducted the interview. He was present. And so if you look at the rule 3.7.
At this point in time, have you subpoenaed Mr. Lewis?
I haven't subpoenaed anybody at this point.
See,
So
you may not want to, might even make out their case. Make out their case against your client.
it might.
I do think that if he becomes a bona fide witness needed in the case, my ruling is one way. If he's not, he's got some other witness that can go forward.
Here's what I'm gonna do then, Judge.
Monica, thanks for the cheers. Thank you,
motion.
thank you,
I'm
thank
gonna
you.
Speak to my client about whether we place Mr. Lewis on subpoena. I anticipate we will. Based on that, then I would ask to be heard on this motion once he's on subpoena as a witness for us.
He would, sure. Now, truly, I do think that you brought up a legal issue as to whether or not the statement can be used at all.
Yes.
As to how the proffer was even, of course, it says crime, and but that's kind of then purportedly went into another crime. And so I don't have a clear feel for what that does when it goes to another offense.
Yeah, I'll be fair with the court. I've never had a proffer where my client has gone in and said something allegedly that was different than the state anticipated, and they've charged. I mean, it happens across the city, across the state, all the time.
But who wouldn't do proffers?
They wouldn't do proffers,
They use against you.
right? But that's what we have here. And so he's in
See, I
custody.
don't have that motion.
I'm saying that, Judge. You may some.
And Judge, just because we're talking about it, Mr. Booker left out what I said after that. I said an exception to that is if he lied. So which is part of, that was also recorded on the recording. I said, there's an exception to this. What I'm telling you is if you make a false statement, if you lie, that can be used against you, can result in a new offense.
Then maybe
So he was informed of that at the proffer as well. Mr. Booker failed to left out when he was informing the court about what was said.
it's not in the portion that it was recorded, Judge, and I'm happy to let the court hear that and play it. We'll just have another motion on that. I mean, I didn't realize we were going to flip flop an argument. But
Well, if you're going to make representations, Mr. Booker, I would appreciate if you made a full representation.
Stop that. If you two want to argue between yourselves, go out in the hall or the parking lot. We get a lot of arguments in the parking lot. So don't do that again. Do not get involved in an argument between yourselves in this courtroom when I'm on the bench.
Yes, Your
Did
Honor.
I make that clear?
Yes, Your Honor.
yes, sir.
All right, good. Now, let's go back to something else.
Yes. So, Judge, I will reserve my argument on the motion to disqualify until we determine if we're going to subpoena Mr. Lewis. I anticipate we will. If I have a subpoena, then we'll go forward at that time.
That changes things. So again, the facts there, I'll rule on the computer right now. All right, but folks, y'all do cases all the time. You're smart people. Let's just plain have fun with this. My gosh. So many things we do are so mundane, you get an actual interesting legal issue. I don't even need copies of those, so that's good.
And just for the record, Mr. Booker and I have a very good relationship.
Well, I would think so.
Typically get along.
You know, I don't usually, but anyway, that's fine. And as well you should. All right, well, that takes care of that. All right, Jennifer, thank you for the help. Start looking at the demurrer and everything else is reserved. We get some interesting legal issues on the proper, which I'm looking forward to hearing as well. All right. That's the fun thing about this. Sure. That's the fun thing about this line of work. If you aren't learning something new, you're not paying attention.
If you're not learning something new, you're not paying attention. We did learn a few things today. We learned how to spell engineering. We learned that his wife's lawyer is unreasonable. Completely. He's in the right. Divorce is always hard. And then, well, guys, thank you so much for coming out. I really, really appreciate it. I hope that you guys have a really, really good day. I'm going to be on later tonight. And I am going to set up OJ right now. So I'll see some of you there. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself.